Hi there. My name is Laurie Ohall, and I am a Florida board certified elder law attorney. And today I would like to talk to you about why and when you need to have a last will and testament. If you ever talk with an attorney, they will tell you that a last will and testament is one of the most important documents that you should have. I tend to disagree, and I'm going to explain why. So, if you only have a last will and testament, the will presumes that when you die, your assets are going to go through probate. And the will, it's kind of like a love letter to the judge. It tells the court who is going to be the personal representative of your estate and who gets your assets. But it presumes that these assets have to go through this probate process before they can be transferred to whoever your beneficiaries are. So many times you will hear people say, well, we want to avoid that probate process. Having a last will and testament does not avoid probate. What avoids probate? Having beneficiaries listed on assets. So for instance, when you have life insurance, usually when you sign up to get life insurance, they ask you, who do you want to be the beneficiary? If you have investment accounts of any kind, you can most times put beneficiaries on them. You can list who you want to have them. And then that way, if there's a beneficiary, when you die, they take your death certificate, they give it to the company, and then they get the money. The beneficiary gets the money. So the biggest things that usually go through probate are the person's house or bank accounts, because banks do not ask you if you want to put beneficiaries on accounts. You have to specifically tell them you want to do that. If you are 18 or older, and you own property, real estate, or other assets, if you have minor children and you want to name somebody to care for those minor children, and maybe you don't have a lot of assets that would justify doing a trust, which is the subject of another video, I will post links down below for you to look at that video. But if you want to disinherit somebody, or you want to make sure you know who the executor of your estate is, and if you don't have concerns about your assets going through probate, then that would be a good reason to have a last will and testament. But it's just really important that you understand that having a will does not avoid the probate process. Having beneficiaries avoids the assets going through probate. Having the assets owned jointly with somebody avoids probate. Having a revocable living trust avoids probate. And these are conversations that you should have with an attorney, not with Google, not with that friend that, oh, he went and did this and got a form. You really need to understand what you're doing and the pros and the cons to doing different things. And, you know, somebody who practices in estate planning would be able to explain all of that to you and help you make the best decision. So thanks for listening. If you like the content that I'm putting out, please subscribe and like below, and I will see you in my next video. Take care.